Hi, come on in. I'm Gerry Oginski, a New York medical malpractice and personal injury trial attorney, and I have to tell you this case that I just read about in the Post. It says $5 million suit lacks common sense. What is it? A woman went to Century 21, bought something with a $5 coupon if you buy more than $50 worth, and as a result of returning something a few days later, she was not given the total amount back. She went to return something for $17.97. They did not give her 80 cents back because they prorated her coupon. So, what did she do? She was outraged. She was upset. She was furious. So she had her father, who's an attorney, file a federal class action lawsuit against Century 21, claiming that hundreds and thousands of people must have been defrauded by the fact that Century 21 did not give the consumer back the full amount of the coupon's value. Can you believe that? Suing over 80 cents? That's unbelievable. Now, why do I bring that up? Well, I'm sure many of you have heard about the McDonald's coffee case, right? Well, what you may not know is the woman who was injured in that case, her name was Stella Liebeck. But I want to tell you something and give you a backstory involving that McDonald's coffee case. You know, every juror I questioned during jury selection knows about that case. But here's some things that they don't know. Did you know that when Stella went to get her cup of coffee with her son-in-law that day, that McDonald's handed her that cup, they kept that coffee at 186 degrees. They intentionally did that because they claimed that it kept the coffee fresher longer. They also claimed that they knew, McDonald's says, we know that this is scaldingly hot coffee, and we accept and recognize that some of our patrons will get burned as a result of drinking our coffee. But that's an acceptable risk that they're willing to take. Why? Because they sell millions of cups of coffee every single day. Now, here's what's interesting. When Stella got burned, she took the coffee, put it in her lap, there was no place else to put it, and as she's taking the lid off, the cup collapses and she suffers burns, significant burns to her groin area and to her legs. Stella came to them, to McDonald's, and said, do me a favor, just pay for my medical expenses and I'll go away. You know what McDonald's said? Absolutely not. So they had no choice but to go after McDonald's in court seeking compensation. So out of millions of cups of coffee sold a day, they came in and testified. They said, we recognize that a handful of people will be burned each year because of what we do. That was so infuriating to the jury. Following the jury verdict, the defense attorneys did everything possible to try and reduce the award. And the trial judge did reduce the award, but they still weren't happy, so they appealed. And the appellate court again reduced that award even further. Stella Liebeck got only a fraction of what a jury felt that she was entitled to. So why am I telling you this? Because we're talking about frivolous cases. Is the class action a frivolous case? You decide. Was Stella's a frivolous case? Not by a lot of standards. Not once you know the backstory. Now, if you found this information useful, what I want you to do is to press the button below here that says like, especially if you're watching this on YouTube or Facebook. Why? So that all of your friends can get the benefit of the same information that you just got. And if you have questions about how cases like these work in the state of New York, then I want you to pick up the phone and call me. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com, and I'll spell it OGINSKI-law.com. I'm Gerry Oginski here in New York. Thanks for watching.